Meeting. I'm Karen Domino. In case you don't know me, I'm the chair-elect. Unfortunately, Dr. Chung is away for his work today, and he asked me to cover for him. I'd like to call the meeting to order now. And the first thing we have on the agenda is the public comment. We will now begin the portion of the business meeting to take public comment. The purpose is to allow members of the public to directly address the Washington Medical Commission on issues of public concern. Please refrain from providing comments on pending or open investigations or disciplinary cases. We will not be answering questions or responding. Staff will be available after the meeting to answer your questions. Please understand that although the time period for comment during the business meeting is limited, the public can attend and provide comments at Washington Medical Commission committee meetings. The public can also contact staff during normal business hours. We welcome written comments as well. We have, how many people, Amelia, signed in? No people signed in who've signed in to speak. If someone was signed in, they would have 2 minutes to speak, and they'd have to state their name and who they represent. So in conclusion, we don't have any public comments today. And so it concludes the portion of the public comment part of the meeting. I want to thank you for any comments or thoughts. Yes, we have someone now. Are they? Oh, okay, well, we'll just wait a minute then. We all have different times. I was looking over here next to me. It was 3 minutes faster than that clock over there. And my watch is even 2 minutes faster than that. So. Yeah, maybe while we're getting going with that, thank you for the suggestion. Because, well, the other thing that as far as a chair report, I don't have a chair report because I'm not chair. I'm chair-elect, and Jimmy didn't leave any particular items to be able to discuss. So the next thing, can we just do the consent agenda as well? Items listed under the consent agenda are considered routine agency matters and will be approved by a single motion without separate discussion. If a separate discussion is desired, that item will be removed from the consent agenda and placed on the regular business agenda. There were 2 items there. If you look at your items in the business meeting, it's 4.1, which is minutes and for approval of the August 26th, 2022 business meeting minutes, and item 4.2, approval of the November 18th, 2022 business meeting agenda. Those are listed between pages 7 and 13 in your packet. Can I have a motion to approve? Do we need a second of a motion? It doesn't say that. Yes, we do. Anyone want to second the motion? Good, we have a second. And then all in favor, say aye. Anyone against? Okay, those are approved. Have we solved our technical issues yet? If not, perhaps we can move on to another agenda item. Okay, well, we'll move on. So we'll go on to old business. The next item is 5.1, which is committee and work group reports. There are a variety of committees listed on page 15. I don't know if any of the committees had met or if any committee has a report. I know the one that I chair, which is the ex-Rome Committee, Patient Safety High Reliability Organization Committee, does not have a report. Are there any other committees that may have a report? And I don't hear of any. So the next item on the agenda is rather long. So I do think if we can solve the problem, or do you want to move ahead with the next item on the agenda? Okay. Okay, that sounds fine. Would you like me to continue on in the order that's in the agenda? Okay, our next item is the rulemaking activity. The rules progress report is provided on page 16. In addition to the written report, Amelia Boyd, program manager, will present the following. And you saw in there, if you should have read the packet yesterday or this morning, there are several rules petitions from Thomas M. Birch. And he is a retired fighter who had made some suggestions regarding the chronic management of chronic pain rules that we have. Amelia, would you like to start and inform us about this?
So it has been a while since we have had a rules petition, about 7 years. I don't think there's anyone on the commission now, maybe Ann Ling, who was here the last time we had a rules petition. So there's a few things that we need to talk about. So first of all, you have to make the decision about whether you will initiate rulemaking based on each petition or not within 60 days. And we received, I think, the first one of these mid-October. So we can't defer this item, unfortunately. And then, so you have to decide whether you will deny the petition in writing. And then you have to state the reasons why you will deny it, specifically addressing the concerns raised by the petitioner and, where appropriate, the alternative means by which it will address the concerns raised by the petitioner, or you will initiate rulemaking based on the petition. So there are 3 petitions. They are very similar. If you read through them, there are some little nuancy differences between them. So you will have to decide for each one that was submitted. And then I think Micah is going to present some information about this particular petition.
Sure. So good morning, commissioners. I just wanted to cover some of the history because quite a few of you are newer to the commission, and just give you some background. So your chronic non-cancer pain management rules have not significantly changed since the 2011, 2012 adoption. Prior to that change, the principle is quite similar to the previous rule set you had and the guidance document that preceded those rules. And so that includes the requirement for pain contracts and biological testing, which is quite a bit of what is at issue in these particular petitions. The major change came in 2017, and those were additions to consider special populations like pregnant persons and youth. And you also added a section on legacy patients, encouraging practitioners to take on new chronic pain patients while maintaining their dosing regimen while evaluating for function and quality of life. That section in particular was authored and adopted in direct collaboration with chronic pain patient representatives who engaged fully throughout that process. The last 2 rule sets came after significant public health and practitioner prescribing failures. They came as requirements from the legislature and can be thought of as giving the regulator a chance to fix the problem before the legislature takes what we'll call a less nuanced approach to clinical medicine. We already know that patients struggle with the systems in choosing to implement the CDC guidelines, which are stricter but still guidance, over the WMC rules, and in some cases apply the Nursing Commission rules, which are stricter still in multi-profession settings. So without telling you which way you need to go, I will just give you a lay of the land of what could happen if you choose to open up rulemaking with the intent of withdrawing the rules as requested. Number one, the perception that the WMC has abdicated its authority in favor of the CDC. The difficult position the other regulators of prescribers who would be placed in if the WMC repealed its rules developed and adopted jointly. And for context, both in 2011 and 2017, the laws amended each practice act of the prescribing regulator, mandating them in identical language to come up with rulemaking. So while we did lead the charge as far as what the content of the rules were, we were a part of a joint process. It will also signal to the legislature that the policy of opioid prescribing is for them to solve, and as in the opinion of the medical commission. So instead of you doing the work of regulating medicine in this particular area, you're telling the legislature that it's their job. And then finally, it could create legal difficulty for the state in its ongoing lawsuits against opioid manufacturers, distributors, and dispensers, whose primary argument is the state, primarily the regulator, or you, failed to act in its rulemaking authority and disciplinary capacity to intervene in the opioid epidemic. And as someone who's been deposed 3 times on this, I guarantee you that is their argument. So with that background, I will leave you to your deliberations on what to do with the rulemaking.
Before we start the deliberations, Heather, do you have some comments about it as well?
Just to add, excellent review. Thank you, Micah. You are required to have rules. So the legislature directed you in statute, as Micah mentioned, and all the other prescribing professions, that you must adopt rules. So I think a full repeal would probably go against that statute.
Let me just start off a comment. I'm an anesthesiologist, but I am in the Department of Anesthesiology and Pain Medicine. I've written articles about patient safety in pain medicine. And one of the items that's standard care among physicians who take care of chronic pain patients is to have urine analyses to test for additional drugs that that physician may not be prescribing. It's for their patient safety. It's and that is really a major, it's a standard component of good standard chronic pain medicine practice. From what I heard Micah say, that is one of the major issues in this. Is that right? I mean, that's what I read out of it. Any other major issues that we need to focus on? Because that is just standard good pain medicine care.
I think that's one of the issues. For full disclosure, myself and our public information officer have engaged with this individual quite a bit through legislative inquiries, and he has explained himself quite a few times in what his concerns are. And so when we've interacted with him, that has been the central thing of not wanting to be on the pain contract because he'd already been on a certain dose of pain medicine for 15 years. And there's no questioning the need for his pain control, but it's a question of whether the practitioners that he was working with were going to follow the rules with their institution and institute these things that were for him new. So I think those are the primary things. I think I would have to call into question some of the statements about the medical commission not working with the chronic pain population. Every single meeting in 2017, we had representatives from the chronic intractable pain group for Washington. And as I said, they basically wrote your legacy section in the rules for legacy patients.
Thank you. Any other comments from commissioners about this? So a pain contract with urine analyses is standard and appropriate care for improving the safety and avoiding overdoses in these patients. Yes, Dr. Yu.
Could you use the microphone, please? Sorry. And then like really project.
Taking my mask off. The rules really is for protecting the general public. There are always exceptions in practice for individual patients. So that should have left out for the physicians or practitioner work out with the individual patient. And as far as rules, that is a much bigger picture that commission is considering to protect the general public. So I agree. I agree with that.
Yes, Dr. Chang.
Well, one thing about the terminologies, and I think the contract, and as far as I know, the contract means is that it's legally binding, goes both ways. So in my institutions, we actually prefer to use the word opioid treatment plan rather than contract, because if it's treatment plan, it's just no different than say if you try to treat asthma, you come up with the asthma exacerbation treatment plan. It's agreement that said this is what we're going to do between the doctors and the patients. But the contract becomes legally binding because the patients say, well, you didn't follow the letter, then you break the contract. Therefore, that void the contract. So we're trying to stay away from the language using opioid contract instead of opioid. So we really recommend using opioid treatment plan.
Micah, in the document is the word contract and in there, because that's a standard, that's an anesthesiologist, pain medicine kind of, that's our standard notation. And contract, I believe, is just a treatment plan between a physician and a patient and not necessarily legally binding. Okay, it's a nuance, right, too, in terms of physician's judgment. If someone has some kind of problem with adhering to the contract, how exactly to deal with it. But I do like that term. I don't know what we refer to it in our rules.
I will look to see it, but I will say that starting in 2011, what you were directed to have in your rules was, and I'll go through this list of 5, dosing criteria, establishing a consultation threshold, circumstances to become exempt from the rule, training and experience requirements, and finally, opioid tracking and accountability tools.
Dr. Chang, does that seem reasonable? I mean, you probably have read the rules.
I think that's reasonable, but I think many times that wording keep popping up, and certainly when from my institutions, when you look at it legally, then that means that the lawyer can actually contest that, say because you break the contract, and they use that against from the languages that we use. So that's why we always have to be very careful using that it's opioid treatment plan. We're actually meant to guardrail in terms of the things. I'm not arguing with the the nuances of that what's in the language is there.
And we've got it what is called as a treatment plan in the rules.
So it answers your question then.
So, and then one more thing, there's a whole subsection about written agreement, specifically for chronic pain. So that's what it's called in the rules, is a written agreement. It doesn't say anything about a contract.
Any other comments about that? I know we need to take each of these separately, and do we want to, and I know they differ slightly, particularly the third one. Should we go through the first 2 and then talk about the third, or talk about, Amelia, do you want to just tell us offhand so we know before we vote what we're voting on?
So as far as I know, the first one, so I will say I struggled to read these because they are so similar. The first and second one are very similar. They point out the same like articles and things like that, and have the same like reasoning behind why they want certain things repealed. The third one actually adds in that they would take back their 2 other petitions if we would add patients older than 65 to the exclusions section of the rule.
Okay, thank you. Dr. Chang, I know you deal with some pain medicine. Aren't patients who are older at high risk for overdoses? Yeah.
Correct. That's why I'm not sure about number 3 petitions, because they actually have higher risk. And that's why you have to have guardrails, put in there. So to say to not to do that opioid treatment plan part, to have that agreement, it's very difficult. To say, that's going to see an increased risk of hospitalizations.
Heather, you have something to add?
This is not on the pain contract issue, but I know 1 and 2, I believe, talked a lot about CDC guidelines and corruption. And just to note that you did not adopt the CDC guidelines wholesale. You looked at those, and you're required by law to consult with the CDC guidelines. So that's why those were considered, as you were required by the legislature to consider those. So I think that would be another thing to add in your letter.
Any other comments about these petitions? So I guess we'll deal with the first petition. Amelia and Micah, how do we go about? Do we have someone make a motion regarding, it would be not adopting it or adopting it? How would rejecting it? What would be the terminology?
So the petitions would be denied if you don't want to initiate rulemaking. So you would vote to deny the petition, and then you will explain your rationale, which I think staff has probably taken down some of the rationale, and you can help with drafting the letter because you have to say your reason for your denial and specifically address the concerns and say if you're taking any alternate means to resolve the issue. But it would be a motion to deny and then reasons why.
So just to help the commissioners, if it's a motion to deny on petitions 1 and 2, it would be a violation of law, RCW, for us to repeal the rules according to what they're being asked?
I think that's one rationale.
Okay.
And then I think you can add in some of the other safety
Sure.
issues and clarifications about the CDC and about the word contract and that sort of thing.
And then for petition 3, it would be the request does not line up with what the available evidence is for those over 65 being an additional risk factor in chronic pain.
I would imagine that would be
Thank you.
a good rationale.
Okay. Do we have a motion for petition number 1? Someone wanted, and the motion is to, do you need to have her go in the microphone?
Forgot to make a motion to deny the petition for this number 1.
Anyone want to second this? Yes, got you. And any other discussion about this? All in favor of denying petition number 1, please raise your hand or say aye. Anyone opposed to denying it? Okay, so in terms of the decision making, you guys have enough concern of what we already discussed. Okay, we have petition number 2, pages 64 to 87. Can I have a motion to either accept or deny this?
I will make a motion. We deny the number 2.
Okay, how about a second of this motion? Have a second. Any other discussion of this? All in favor of denying petition number 2, raise your hand or say aye. Anyone opposed? Okay, we deny petition number 2. Finally, we have petition number 3. That's page 88 to 95 that tries to make an exception for patients over age 65 who we heard from Dr. Chang are at higher risk of having adverse patient safety outcomes. How about we have a motion to either accept or deny that petition?
I move to deny the third petition.
Do we have someone second this? Dr. Yu. Any discussion of this, further discussion? Okay. All in favor of denying petition number 3, please raise your hand or say aye. Anyone opposed? Okay, so that settles what we think. We do really appreciate Thomas Birch's problems and concerns. We're sorry. We did really consider things, as you heard, if he will hear hopefully in response by the commission, that we are really concerned about patient safety. And in using words such as treatment plans and allowing flexibility between patients and treatment is our goal. Any other comments about that? All right, the next thing I have on this list is a request to rescind medical records rules initiation approval. And
Yes, so some time ago, we presented a request to initiate rulemaking on medical records. In the meantime, we've did some work in the background and have decided at this time it's probably not a good use of our time to pursue rulemaking on medical records. So our request here today is just to rescind that approval to initiate rulemaking, just to tie that one up.
we need to have a motion, is that correct? Do we have any discussion of that item? Yes.
I was just interested, what were we trying to fix?
That's a great question. We weren't real clear about what we were trying to fix. Sometimes we have issues, we sometimes get complaints that like a patient can't get their medical records and.
Or change it, someone wants it
Right,
changed.
right. And then sometimes we have issues when we're doing an investigation getting medical records. So we were thinking about maybe trying to fix those issues, but we still don't have enough real clear direction on that. So we just, at this time, don't feel like we have enough to back us up to just do rulemaking, because it's a long process, it's expensive and those things, so.
Thank you.
Any other comments, suggestions about this? We have a motion to rescind the medical rules initiative. Okay, anyone seconding? Yep. And any further discussion? All in favor of rescinding this rule making process? Say aye or raise your hand. Anyone opposed? Okay, we voted to rescind medical rules initiative approval. All right, there's a request to rescind interpretive statements. There appear to be 2 interpretive statements or 3 interpretive statements. Amelia, can you tell us about what these are?
Yes, so we sometimes when statutes are put into place, we do interpretive statements because there's not enough clarity in the statute. And so when we did rulemaking recently for the IMGs, we had already created a couple of interpretive statements to provide them with some information, but we have you just approved at the August meeting rules for the IMGs. So we're just asking to rescind these interpretive statements because they've been incorporated into that rule. And then on the third one, so just like we talked about a minute ago, we do have some new exemptions in rule for opioid prescribing, and that covers like long-term acute care and nursing homes and rehab centers and things like that. So we did have an interpretive statement that talked about exempting patients in those facilities, but we have incorporated those into rules. So we are asking to rescind that interpretive statement as well.
Any comments or questions about this request? Thanks, Amelia, for explaining it. Can I have a motion to rescind these? Are they 3 interpretive statements? Okay, great. Anyone seconding? Dr. Good. Any further discussion? All in favor of rescinding the 3 interpretive statements? raise your hand or say aye. Anyone opposed? That passes. All right, and then we have a final request to initiate rulemaking regarding SB 5229 concerning health equity, continuing education for healthcare professionals.
So this bill was passed this last session, or maybe the one before, and it directed the agency, so the Department of Health, to come up with model rule language for all professions, which they are in the wrapping up period of that. They have model rule language. And so now part of that bill is that we are directed to create rules around this continuing medical education requirement. So we will have model rules to work from because the department had to do that. And we have to complete this rulemaking by January 1st, 2024. So we do have some time. So that's our ask today, is to initiate rulemaking on this.
So let me just say, I work for the university, so it is a state organization, and we've had extensive training with regard to these issues. And I found it just absolutely incredibly helpful. Even though, like, for instance, to interview our residents, we had to have 40 hours of training last year. Now I think we're coming through with 48 hours and of different lectures and personal type of, interactions. And I've thought it was outstanding. Some of the content we have is exceptional. So that's just my feeling, having undergone that kind of training, and in the process, I think it's worthwhile. I think it's actually really worthwhile for people on the commission as well as for all healthcare providers. Any comments about that or other things other than my personal experiences with what the training that I've been undergoing? Ms. Sprague?
I agree with that, Karen. There's a lot of education and committees that are going on in hospitals too, and I think that all providers should have this type of education. So I'm all for this.
Any other comments? Dr. Yu?
Just a question. This rulemaking is set for, healthcare professionals. And I wonder, this is only for this commission. Is this only for physicians and PAs, or is for all others?
So it's for all the healthcare professions, but your authority is over MDs and PAs. So like I said, the DOH has created model language for all of the health professions to put into rule. So ours might vary a little bit, like how many hours you would like them to take, things like that. So, but it'll be very similar across all professions once we initiate the rulemaking.
Okay, got it. Thank you.
Any further discussion on this item? Can I have a motion to initiate rulemaking regarding health equity, continuing education for PAs and physicians? Okay, since there were two, I assume one of you will be the second of that. Any further discussion on this? All in favor of this, initiating this rulemaking, say aye or raise your hand. Anyone opposed? Okay, that passes as well. Oops, sorry, 5.3, Open Public Meetings Act. Heather.
Yeah, so we do try to do an annual refresher on the Open Public Meetings Act for all of you. I know all of you have had the initial training, and this is just a quick sort of 5-minute refresher so that everyone sort of has it at the front of their mind so we don't get ourselves into trouble. So the Open Public Meetings Act is a government transparency act passed in the 70s. It's been amended even last session along the way, but it applies to state and local governments that have a multi-member governing body. So you have 21 members and our governing body, so it applies to you. It applies to other state boards and commissions, as well as local governments like your city councils and that sort of thing. It can also apply to committees of your governing body. So any of your committees who are delegated authority to make decisions on behalf of the full commission or taking public comment or public testimony, those subcommittees or committees are required to comply with the act. And most of the requirements are around notice and agendas and all of that sort of thing, and your staff takes care of that. So a lot of the technical issues you won't have to be doing, but because Amelia is going to take care of those, but there are some pointers along the way for individual members. The act does not apply to your licensing and disciplinary cases. That's why all of your disciplinary calls and panels are closed to the public, because it doesn't apply to those. Also doesn't apply to your hearings and doesn't apply to your rulemaking hearings, although you tend to comply with those anyway, because you're usually part of a meeting. So the Open Public Meetings Act applies to anytime there is a meeting, and a meeting is any time you meet a quorum or a subcommittee that is required to have any sort of discussion, deliberation, vote, evaluation. So it doesn't require, it's not triggered just by having a final decision or having a vote. Even if you have a meeting where you're going to discuss anything or have a deliberation, those are still going to trigger the act. So it's, a lot of people think, well, we're not going to vote, so we don't have to have it open. Well, that's not the case. Anytime you're going to get together, a quorum, which I think is 11 of you together, you need to have it open to the public and provide the proper notice. Meeting can also take place in email or on remote meeting or telephone call. So this is sort of one of the big reminders for all of you is a meeting can take place if there's 11 of you on an email exchange, and you could violate the act that way. So my reminder, and I think staff try to blind copy you so you can't reply all, but try to get in the habit of not replying all when you're getting commission email. That will eliminate any of the risk that you might create an online or email string that creates a meeting. People are always asking me, can we travel together? Can we have dinner together? And I know some of you, there's a group of you that had dinner together recently. Yes, you can. You can have a quorum, traveling together, going to dinner. You just can't discuss commission business. So just, keep it to the Mariners and the freezing cold weather this morning, and those sorts of things, and don't discuss the commission business during those times. So there were a couple changes that some of you that have been around a little longer wouldn't know about in the last legislative session. So the legislature amended the act first, mostly to kind of update it due to the COVID emergency. We didn't have a provision in the law to have a fully remote meeting. So the governor during COVID had to suspend some of the statutes so that would be allowed. So the legislature went in to try and fix that. So they did add a provision that if there is a declared emergency of any sort, local, state, federal, and you determine that it's not reasonably safe to meet in person or with the public, you can exclude the public. You can meet fully remote in those instances. So there's no state emergency in place anymore. Those expired recently. There still is a federal public health emergency in place, and some boards and commissions at DOH are still making that evaluation on whether or not it's safe to meet in person, and they can do so. The other change was the legislature added a public comment requirement. The act before has always said that public can come and observe, but they aren't guaranteed participation at a meeting. That has changed. Now there is a public comment requirement. You can do that orally or in writing, but if you do require the public comment in writing, it has to be in a certain amount of time ahead of time, and it has to be distributed to all of you. So we've sort of taken the approach that it's much easier just to have a public comment section at the beginning of the meeting, so that we don't have to worry about making mistakes on requiring all the written comments and timelines and all of that. Of course, you still allow written comment at any time, but we just make sure we don't run afoul with that requirement by doing. So that's why you have public comment at the very beginning, so we can comply with that. There are times when you will have what's called an executive session, which is when you meet all together and exclude the public. You can ask staff to stay at those. Those are only allowed if you meet certain requirements that are in the law. I will say the most common for healthcare boards and commissions is when you need to meet with your AAG to discuss potential litigation or pending litigation. I know you've had tort actions where you've had to discuss settlement or strategy. With the torts AAG, there are times you may need to meet with me where I can provide some guidance on some action you may be looking to take that may have some legal consequences that would be adverse. So there are times. The other, I think the only, Yep, that's the only other time I've seen this group use the executive session is for personnel evaluations or for hiring decisions. Those can be made in executive session. You can't vote in executive session. That is one sort of caveat. So you can have a discussion, but if any vote is going to be taken, you have to go out into the public session and make any final vote. Lastly, penalties if you violate the act. Each member who knowingly violates the act is subject to a $500 penalty. The commission can be liable for attorney's fees, but really it's not a huge, the $500 fine is not a huge financial consequence, but really the publicity and perception that you are violating law and doing something in secret is sort of the most adverse consequence in my view. But that's sort of my quick, overview refresher. Does anyone have any questions? Nope. Okay. Thank you very much.
Thanks so much for the presentation. All right, I guess we're moving on now to the policy committee report. Ms. Blake?
Good morning. We met last night and had a few policies that we took a look at. Hopefully you had an opportunity to see the email that came out from Mike with some of the updates to those policies.
Can you tell us what those are? I know
Sure.
I didn't look at it.
Absolutely. I'm going to start with the medical marijuana one, though, however, there were no changes to that except some suggested modifications to language, but otherwise there were no other changes. Did everyone get a chance to look at that? And do you have any questions? Okay, the other two policies that we took a look at that were amended, one was reentry to practice for suspended licenses. We added reentry to practice for practitioners with suspended licenses. The other modification to that was to take out he or she and put they have, so that the pronouns are not in there. The other modification that was made on page 1 of the document is a list of reentry programs can be found at the end of this guidance document under resources. And the other modification was obviously listing all those resources at the bottom of the document. Does anybody have any questions about that particular? And the last one that we took a look at was, let me pull it up here. Mike, I think I've lost it here in my, if you can.
It's reentry to
Reentry to
practice.
practice.
So those are for people who didn't have any action against their license, right? Those are
Correct.
Yeah.
Mike, do you want to go over that one for me? For some reason, it's not pulling up if you have it. Yeah.
Microphone, please, Mike.
Good morning, everyone. We made a few changes. So this is a document that was developed, I think, back in 2015 when reentry was a big issue, and we wanted to help practitioners find ways to get back into practice. And it arose out of a case involving a practitioner who had a little bit of trouble with us, and she was out for a while. And one of our staff attorneys worked with her to find a way through DSHS actually to rehabilitate herself and get up to speed. And it was a success story that we were pretty proud of. And so we developed this guidance document to provide information to practitioners on how to do it. One of the main changes was that we had referred people to the University of Washington Medical School. They had a program for reentry. So I clicked on that link. The link didn't work in preparation for this meeting. And I looked on their website. I couldn't find anything on the UW website about their reentry program. So I emailed them, and they emailed back, and I emailed them and asked them, do you still have a reentry program? And they sent us a note back saying, no, we don't. That's why we added the resources at the end. And in this document, you'll see taken out any reference to the University of Washington reentry program. So that's why I list 6 or 7 resources at the end. At the beginning of the document in the background, there's a statement, this issue cuts across all genders and specialties, but may affect women more than men. We decided to take that out. That came from some materials I was looking at back in 2015. It's really not necessary to point out that it affects more women than men. So we decided to delete that. Under definitions, we, again, as Ms. Blake pointed out in the previous one, we changed he, she to they. And I think that covers it.
Thanks, Mike. Anybody have any questions about those revisions?
Sure. Can you explain the difference between the informal entry and the formal entry on re-entering practice? You said the ones between 12 to 24 months can do an informal, whereas above 24 months should be formal. What is the difference?
Can you point to the part of the document where it says 24 months?
So if on the re-entering clinical practice, says the commission encourages practitioners who have been inactive for 24 months or more to complete.
Sorry, we need to just have one mic on at a time. So Mr. Farrell and Ms. Blake, if you could turn yours off. Thank you.
It is under the paragraph for re-entry clinical practice. There's one way it says informal and there's one way it says formal. So I wanted to know what is the difference.
I think the difference is that the second sentence, talking about 12 to 24 months, we use the term informal reentry program. And I realize now we don't explain what that is. So I believe the intent was somebody's been inactive for 24 months or more to complete a formal reentry program. We can certainly try to clarify that. I realize now that that's not clear at all. What is an informal reentry program? So I think we're trying to say, I think the commission is trying to say 24 months or more, go to the University of Washington or a formal retraining program. 12 to 24, some type of informal training program that we're not defining in this document.
So just after consulting with our licensing manager, we do have a trigger time frame of 24 months. If you are out of practice for 24 months, that means that you need to complete a full reactivation application. And it also gives the discretion to the panel L if they would like to see some sort of evaluation, test, training, or anything else before you come back. Generally, what we're seeing with that is a request that there is a preceptor or something like that. So that's the informal piece where they're saying, okay, you have to report back to the commission. Your preceptor has to report back to the commission over the course of say 6 to 12 months, just to make sure that your progress is good for reintegrating back into practice.
Terry?
I don't know that we have to define informal because it might limit the needs of an organization to use what would work for them in terms of mentorship, preceptorship, buddy, double coverage, that kind of thing. And I wouldn't want to limit that. You know, we have vast variety of practice patterns and needs and rural versus urban. And I think if we got down to having to define informal, it may place limits that we don't intend. Thank you.
Yes.
Madam
Mr.
Chair.
Lopez.
Yeah, Madam Chair, I'd like to echo what Dr. Murphy has said. I think we would do a disservice to get into the weeds of being prescriptive of what we should and shouldn't do for formal versus informal.
I would agree with that, and thanks for those comments. I think that makes sense.
One more clarification. So I just want to know, the resources you have given us, are those the ones only approved, or if somebody finds something which we were not able to capture here, they can be able to use it?
Yeah, the intent was not to list programs that are approved, but just to put resources. They can go to any program they want and then come to us. And these are just programs that I did with a Google search and going to the AMA website. So if anybody else knows of a program, I'm happy to add it. Micah, can I ask a question? What you said about licensing, just so. I think you said, Marissa said 24 months if they're out of practice. Do you mean an expired license or revealing in renewal that they haven't been practicing?
I believe expired license is what we're talking about there.
Okay. So this document covers anybody who's been out of practice. It doesn't have to be an expired license.
Ms. Blake? Yeah. I just have a comment on about the female, where the difference of reentry between female and male providers. I just want to share just a tidbit that when I work with NSF and we, writing grants or we're getting training, we recognize that lots of time because female scientists have to have, childbearing, have to take out of work, maternity leave, and all the things that make it sometimes difficult for them to have the same level of reentry back to the science. I don't know if the same in the healthcare or not. I just want you aware of that. Sometimes it may be a little different. There are difficulties and barriers to get back in the practice sometimes.
Are there any other comments or questions? So no revisions to this particular request. Thanks. And I think, Micah, you have something that you wanted to bring up. I'll let you explain that one.
Thank you. You received an email this morning from Mr. Farrell with the revisions to the policy statement that establishes a clinical experience assessment. And so the background on that is explained in the policy statement, but I'll briefly go over it. The Medical Commission has sort of been central in working with international medical graduates, or IMGs, to collaborate with legislative efforts to integrate them into the Washington healthcare system. First with the IMG work group, and then once they submitted that report, it created the IMG implementation work group. So what you're seeing before you is part of a legislative requirement that they come up with clinical readiness criteria and recommend it to you, the Medical Commission, for adoption. So that's what this is in front of you. This is something that is taken from the ACGME with respect to criteria that are evaluated. The entrustment scale is also taken from ACGME, and it was developed or put together by a couple of folks from UW, as well as other members of the IMG work group. So as background, I'm a member of that. I'm the WMC representative there. And so I'm bringing this to you for adoption today. We did have some slight revisions last night, just based off of some technical things that were recommended, and some Scrivener's errors. So what you're doing today is not, and I saw you jump up, Amelia, not necessarily adopting. Because it's a policy, it will need to be recommended to go through the secretary review process, which is when we send it through the secretary's office. They look at it and suggest changes. It comes back to you, you consider the changes, and then you accept or reject, and then adopt the final policy. So at the latest, you would adopt this, or the earliest you would adopt this in January. But the recommendation at this point is to send it through secretary review.
Any questions or concerns? Okay, I'll take that as a no. And that concludes the report of the policy committee. Do we, oh,
We
I'm
need to
sorry.
vote.
Yes, we need to vote on that. My apologies. May I have a motion?
I move.
Second? All in favor? We had a second. Thank you.
Thanks for that report.
Dr.
Are we now
Domino,
open for the
Yeah.
public comment? Isn't that part of the policy report? She did all those together? Yes. So we're now redoing is this a good time for the public comment? Okay. They know they have 2 minutes to speak. Okay.
Okay, so I'm just going to read this verbatim and leave it up to you guys. Thank you for your time today to share briefly updates on healthcare for the chronic pain community. Post-COVID crisis, we awoke to some troubling developments for people in pain and for those who prescribe for them. First and foremost, there has been a targeted shift in direction and funding to develop tools to predict OUD or overdose in patients on LTOT for chronic pain. Risk assessment agenda is being pushed even though 97% of these never develop OUD and 99.66% of them never die of an overdose. One such existing risk tool is the use of machine learning algorithms. Ambitious PMP vendors are already selling their algorithms as a PMP package add-on without FDA approval. One such algorithm program is NarxCare by Bamboo Health. NarxCare leverages info within the PMP and combines it with other personal data, such as electronic health record, claims data, criminal justice data, pharmacy data, and more, to calculate a person's risk of overdose or developing OUD. NarxCare calculations are proprietary and customizable by state. This data is without context and does not translate into clinical care, especially for patients with chronic complex medical conditions. Washington DOH is getting ready to sign a new PMP contract with Bamboo Health by the first of the year. The sole source contract includes language that would allow Washington to flip on the NarxCare switch option upon funding. We do not want that to happen. The potential for patient harm in Washington via NarxCare is phenomenal. Patients in other states have lost access to their pain medications because they were inappropriately flagged. A flag could be because they drive a long way to see their pain specialist. They have used more than one pharmacy because of supply issues or because they're co-prescribing information without clinical context. Providers will be tempted to use NarxCare as a quick fix to decide who gets to have their pain treated. Because of the perceived and existing national squeeze on prescribing, any red flags will subliminally mean no opioid medication, even if there was a need in clinical context. There is absolutely no reason for the DOH to opt in on NARCS care. Patients on LTOT are not overdosing, developing OUD, or diverting their pain medication. NARCS care is plagued with ethical, efficacy, and discriminatory issues, and it's costly. It has potential to harm patients by putting data before clinical context. This is only a win for Bamboo. Please ask the DOH PMP team and decision makers to opt out of NARCS care. Next, patients need expanded protection against discriminatory algorithms in deciding their care. We have a few ideas about how to do that and we'll be in touch soon. Respectfully, Cindy Hohenhaus, co-chair of the Washington Patients in Intractable Pain. And I do have one more. I am Rose Bigham, co-chair of Washington Patients in Intractable Pain. Our comments today were simply to reiterate that we, as the largest pain patient advocacy group in Washington state, remain available to partner with the WMC on issues regarding pain management and lack of access to pain care. We know that the WMC is aware that the patients with serious pain issues are going without care in our state, and that can make them desperate. Patients with care know that their providers are continually under pressure to lower or discontinue prescribed opioids regardless of patient history or prognosis. People with acute care are continually shocked to learn their pain issues are dismissed and undertreated in emergency departments across the state. We are here representing these patients, and we are available to partner with the WMC and others on issues which affect both patients and providers alike. Please remember to include patient advocates in new policy groups which impact this population, as we can help articulate the real and ongoing barriers to pain care. Thank you for your time. And please let us know if you have any further questions on the topic of chronic pain in Washington. We are reasonable and available to provide any information you may need on the topic. And that concludes the comments.
Thank you so much. All right, it looks like our next number 7.0 are member reports. Does anyone on the commission have any special reports? Dr. Yu.
I don't know if maybe some of you are already aware that on Monday, the Secretary of Health, Human Services, Health and Human Services convened a meeting in DC to renew their focus and efforts to advance patient safety. According to the data from their own strategic plan for 2022 to 2026, there's still estimated about 550 patients died each day from medical errors. So the national trend, especially during the COVID, it has been the quality, patient safety have been backwards due to multiple, factors. We all know the difficulty. So the Human Health Services in efforts with the HRQ, CDC, CMS, FDA, and all the stakeholders and the large healthcare system created what's called Action Alliance to Advance Patient Safety. So they were going to develop plans and how to advance patient safety together, draft the plans. And I think Commission is in a perfect position to, to advance patient safety. I know you all work hard on that. This may be my truly last meeting at this commission. I mean, like the rabbit, the energized rabbit is just keep going. So, but I appreciate that you all do, and I hope you keep it up good work to, really advance patient safety. So thank you.
Thanks so much, Dr. Yu. Glad to hear they're working on patient safety in DC. Any other member reports? I don't see anyone raising their hand, but I can't see everybody. So we will move on to staff reports. Melanie has a,
Oh, okay, sorry. So this is not really a new report. I'm just kind of giving you a heads up FYI. I was on the other end of phoning in yesterday for a case review, because usually I'm in the room and the people phoning in, I don't know their experience, but I experienced it and it was terrible. So the next time we do case reviews and you have a phone in, we may have the person doing the case presentation within the room use a microphone, because the people on the call cannot hear you. I was on the call with you, Chris, and I heard every third word, maybe. It was just breaking up. So we're trying to increase our technology use so that everybody has a great experience. And so that's just an FYI. In January, those in the room may be required to use a microphone when you're talking with a person on the phone. That's it.
thank you. I just have one comment about the member reports. And that's something that if you look on the one from Ken Imes, saying if you leave the country, which Canada is, Victoria is outside the US, that your computer won't work. This happened to me. And I know Ken really tried hard to get my computer to work during the week long I was there for doing some lectures. And fortunately, I'd reviewed all the cases in advance, but I could never get, initially I was able to get into the X drive, but that ultimately went away. He says 1 week when I was talking with, it took him like a couple days to be able to get it, fixed. But then when I talked to the DOH IT people, they said that actually they like 2 weeks in advance to prove that you're not having some kind of safety risk by going away to Canada. So it was funny because I could hear the radio station I listened to all the time from my hotel room and look across and see the Olympic Mountains, but it was Canada. All right, yes, Micah.
So just to add on to my staff report, so per the public comment, just addressing the NARC-X care, you already addressed to some degree AI machine learning use tools in your telemedicine policy, just as FYI. So it's at the very end. It's a brief section, but if that doesn't, if you don't feel that empowers the licensees to make decisions, and that's really usually the risk with clinical decision-making tools and AI tools, where they're doing the thinking for you and just saying, do this. That's what we're trying to head off with those particular statements. So if you wish to address that further, that's certainly something a work group that could get together and look at that scenario. I also wanted to let you know that based off the new CDC guidance issued this month, and I didn't want to say this during the rules petition to potentially bias you, but based off of that guidance being issued this month, we are having an external expert review the CDC guidance and compare it to your rules to look to see if there's any gaps or conflicts. And next month, I expect a report from that individual. So if there are any actions that they recommend taking, we'll convene a subgroup to see what needs to happen and then potentially initiate rulemaking based off of that. And finally, I'm going to look around and see if she's here somewhere. Taylor Bacharach Nixon is our new staff member. Just wanted to introduce her. She's working with licensing as well as the legislative group and supporting me. And so she's our newest member, and just wanted to welcome her to the commission.
So Micah, you just want any volunteers who want to work on AI issues?
I would recommend waiting until the policy meeting in January to discuss what we would want to try and accomplish with that, because it is a sensitive area with our stakeholders.
Great, thank you. Any other staff member reports? Not seeing any. Heather, you have a AAG report?
Just super quickly, earlier this month, I was able to go to the FSMB attorney roundtable with, I think, about 6 other attorneys from the commission, as well as one of your prosecuting AAGs. And I just wanted to give a shout out to Mike Farrell, who was on the planning committee for that. It was an excellent presentation or workshop, great presentations. Trisha Wolf gave a presentation on some of your COVID things. I was able to present on some general counsel perspectives. And I just wanted to say it was a great workshop. So thank you.
All right. Anything else? Are we all finished as far as our agenda items? All right, so it's 9:10 and we will adjourn the meeting. 9:45 are when our respondents are visiting us for personal appearances. So please be in the room several minutes before then, ready to see them. Thank you.